Good evening, everybody. Thank you for joining us this evening for the first of our seminars this year, Property Law Nuts and Bolts. And this one is an introduction to business tenancy renewals. There will be a series of other seminars like this one later in the year, so do look out for that. We're delighted to see so many of you joining us today. I'm told that there are around 640 people that were registered. I can see the participants list going up as we speak, and that's really fantastic. So thank you for coming along this evening. My name is Brooke Lyne, and I will be chairing this session this evening, and I will be doing a talk at the end if my colleagues leave enough time for me. I will introduce my colleagues Peter Sibley and Ashley Thompson in a moment, but before I do so, I'm just going to give you some very boring housekeeping points to bear in mind first. Your microphones are automatically muted. You don't need to do anything, just leave it as it is. You are very welcome to ask us questions throughout the session. Can you put them in the Q&A section? It should be at the bottom or the top of your screen. If you want to remain anonymous with your question, if you think that the question is really silly, and there is never a silly question, then you do need to click on the send anonymously box before submitting it. We will try at the end to answer as many questions as we can. This webinar is recorded, and after the session ends, you will receive a link to the presentation and the recording. If at any time during the session you lose connection, then the best thing to do is just log out, disappear, and then come back and rejoin the meeting by clicking on the original link. So that's all the boring stuff over. Perhaps now I shall introduce our speakers. I'll start with myself. As I say, I'm Brooke Lyne. I am a specialist property practitioner. I was called in 2016, so I've now been doing this job best part of 8 years. I do both commercial landlord and tenant work and a full range of residential landlord and tenant work. In the last year, I've had a handful of Ground F 54 Act claims, all of which have settled, which has been incredibly frustrating. But hopefully we'll be able to provide you with some of the insights that I've had in some of my cases. You will also be hearing from Peter Sibley, who joined Landmark as a tenant on the 1st of October 2021. That is 3 years to the day, so you're lucky to have Peter here on his anniversary. And that was after he had successfully completed his pupillage with us here at Landmark. In the 3 years he's been in practice, Peter has already established a very busy practice spanning the full range of property work. He's been involved in various 54 Act claims, and he does a lot of possession work involving commercial premises. So he will be an excellent speaker when it comes to dealing with the procedural parts of lease renewals. You will also hear in a moment from Ashley Thompson, and he's going to be talking about notices this evening. Ashley literally joined Chambers today as a tenant, the 1st of October, having been with us for the last year as a pupil. So rather than being at the pub this evening, which is precisely what I did on my first night of tenancy, you guys are lucky enough to have him here talking to you about notices under the 54 Act. By way of context, Ashley moved over to the dark side, but prior to that, he was a solicitor. He joined Herbert Smith Freehills in 2018, where he trained and qualified. He was then at Mishcon de Rea after that, where he specialised in all aspects of property litigation, which of course included an inordinate amount of commercial lease renewals. In fact, Ashley tells me that he thinks he served close to 100 notices over the course of the last 5 years. So he is very well placed to tell you all about those. So without much further ado, I'm going to pass over to Ashley, who's going to start with the first talk.
Thanks very much, Brooke. As Brooke mentioned, I'm going to start with notices. Bear with me 1 minute so I can get the screen working. Fab. So you're dealing with a lease within the 54 Act. What does that mean? Well, crucially, the tenant has security of tenure. And there are 2 incidents of that. The lease will continue when the contractual term expires, and it could continue indefinitely. And the tenant is entitled to a new lease after its current lease expires, unless the landlord successfully opposes. Upon contractual expiry then, what next? Well, the lease will continue automatically by reason of section 24 of the Act, or it can be terminated without renewal or it can be terminated with renewal. And when we're talking about notices, we're talking about termination with or without renewal, as the lease will automatically continue under the Act. So section 24, subsection 1 of the 54 Act says that a tenancy to which this part applies shall not come to an end unless terminated in accordance with the provisions of this part. And that means that unless the Act otherwise says so, you can only terminate using the prescribed methods. Before turning to those statutory methods of termination, I just wanted to mention quickly that some common law methods are preserved by the Act. We see that at section 24, subsection 2, and that reserves termination principally by surrender, so express, implied, by operation of law, forfeiture of the lease where the tenant is in breach, or forfeiture of the superior lease, i.e. the branch falls with the tree. So now onto the statutory methods. So how do you terminate the lease with or without renewal? And this is generally speaking, because it may depend upon timings, which I'll come on to. If your client is a landlord, you'll be looking to serve a section 25 notice either way, renewal or not. If your client is a tenant, and if they're proposing renewal, they'll serve a section 26 notice to trigger the process. If they don't want to renew, they either vacate the premises pre-expiry of the contractual term, we'll come on to that, or they serve a section 27 notice, and we'll come to the rules on when you can serve those in a moment. So we'll start off with the easiest, and it has to be a section 27 notice. So these are served by tenants. As noticed, they're served as an alternative to simply vacating pre-expiry of the term, or you can serve it post-expiry. So this is where the tenant does not want to renew the lease. You can use a section 27 notice to terminate a fixed term tenancy. You can't use it to terminate a periodic tenancy. So if your client is on a periodic tenancy within the 54 Act, which is entirely possible, the tenant can serve a notice to quit. Don't go down the section 27 route. You can't serve a section 27 within the first month of the tenancy, and has to give at least 3 months notice. And that's why if the tenant wants to terminate within the term, it may simply be easier to vacate. That fits in neatly to the type of section 27 notice that you'll need to serve. If the tenant is giving notice at least 3 months prior to the contractual expiry, so it simply wants to notify the landlord that it won't be renewing at the end of the term, it will serve a notice under section 27(1). The tenancy will then expire on the contractual expiry date. At any time after that, it will be a section 27(2) notice. So easiest way to get your head around it is by giving an example. So the lease has a contractual expiry date of the 31st of December, taking an easy one. If the tenant gives a section 27 notice on the 1st of June, it'll be a section 27(1) notice, because there's at least 3 months left on the term, and then the lease will expire on the 31st, so the contractual expiry date of December. If the notice is served on the 1st of November, it'll be a section 27(2) notice, and that's because there are fewer than 3 months left of the contractual term, and the lease will only be able to expire on the 1st of February, so that's the 3 months notice you've got to give. If you give a section 27 notice at any point after the 31st of December, it'll be a section 27(2) notice, like the one before, and the lease can expire after the 3 month notice period is given. Now, there isn't any prescribed form for a section 27 notice, so you can simply send a letter. I would always advise, as I've just mentioned, to get the section right, the subsection right, 1 or 2, to avoid any potential challenge down the line. We then move to section 26 notices. So this is where the tenant wants to renew the lease. And the section 26 notice will trigger that renewal process. Now, what's important to note is that the serving of the section 26 notice correspondingly brings the lease to an end. So the tenant has to issue lease renewal proceedings if the parties ultimately fail to complete the new lease by the relevant date. Now, that relevant date is the date in the notice. That will be the commencement date of the new lease. So naturally, the current lease will come to an end the day before because you're wanting a new lease on the day after. That commencement date cannot be earlier than the contractual expiry date in the lease. So if we take our previous example, the 31st of December, can't be before then. In terms of notice period, the Section 26 notice cannot be served fewer than 6 months before the commencement date that you put in the Section 26 notice, nor more than 12 months before the commencement date. So you effectively have a 6-month window in which to serve the Section 26 notice. It has to be in the prescribed form or in a form substantially to like effect. That's what Section 26.3 says. I would always recommend using the prescribed form, and I expect solicitors always will. So this situation will typically arise where the client has already served the notice and then instructs solicitors, which is arguably never a position you want to be in. In that situation, the lawyer's job is to compare what has been served as against the prescribed form. Sabella and Montgomery is an example of a case where the warning notice in the Section 26 notice was missing from the form of the notice that was served, and it invalidated it. If there is any risk, then I would always recommend serving a fresh Section 26 notice without prejudice to the first, if necessary. But it's not worth taking the risk that that will be invalidated. If it's invalidated, there is no foundation for the lease renewal proceedings. The schedule to the prescribed form has to contain the tenant's proposals for the new tenancy, so it has to include what the property is going to be, what the rent is going to be, and what the other terms are. Now, this is very important because it is the tenant's formal position, so it doesn't really matter what's happened in negotiations. This is the tenant's base position when it comes to proceedings going forward. Another important thing to note is that they can't be unilaterally withdrawn. The lease will come to an end on the day before the commencement date in the notice. And finally, because this is a notice where the tenant is saying, I'd like a lease renewal, if the landlord wishes to oppose, which they're perfectly entitled to do on the basis that they can make out one of the opposition grounds, they have to serve a counter notice within 2 months of service of the Section 26 notice. So we now move on to Section 25 notices, and these are notices served by the landlord. And it can take one of two forms. It can either be what's colloquially known as a friendly notice, so the landlord wishes to terminate, but is happy to engage in the lease renewal process and proposes terms for the new tenancy. Quite possibly not happy about it, but can't make out any of the opposition grounds, so it's possibly necessary. The other form of notice is a hostile notice, and that's where the landlord wishes to terminate and oppose the grant of a new tenancy on the basis that they can make out one of the opposition grounds. And by way of example, those opposition grounds include demolition of the premises, or that the landlord wishes to go back in and occupy itself. In the case of either notice, so a friendly notice or a hostile notice, it must contain a termination date. Now, I must stress, this is a termination date, not a commencement date. And that means that when will the lease terminate? It'll be on the date in the notice, not on the day before, like with a Section 26 notice. However, like a Section 26 notice, the landlord has to provide between 6 to 12 months notice, no more, no less, which means that there's a strict window there. And the Section 25 notice has to be in the prescribed form. There is the saving grace, again, that it can be in a form substantially to like effect. I'll re-emphasize until I'm blue in the face, always use the prescribed form. It's simply not worth the risk. Finally, the date that's specified in the notice, so the termination date, can't be before the contractual expiry date. And again, a Section 25 notice cannot be unilaterally withdrawn. If there is any risk of an error in the notice, for example, I would always recommend serving a fresh notice without prejudice to the first. Now, as Brooke noted, I've served many of these notices, and I tried to think of what would be most helpful to all of you. What are the most common scenarios that throw out issues? So if there are any takeaways, this is the most important slide. The first one is service. So Section 66, subsection 4 of the Act allows service by prescribed methods. Those prescribed methods are found in Section 23 of the Landlord and Tenant Act 1927. So they're the usual methods of service: personal service, leaving it or posting it to the landlord or tenant's registered offices. B&B estates and egg stores provides that the notice is deemed served on the day it is posted in accordance with the Section 23, sorry. Now, Jazz, I think something has come up on the slide. I don't think that was me. Oh, it's gone, fine. The difficulty with that, and it's the same difficulty that's faced with Section 196 of the Law of Property Act, is overseas landlords. Now, Section 23 only provides for service on a registered office in England and Wales. And if you can't rely upon deemed service, then unfortunately you're back to the common law rules, which means that service occurs upon receipt. That's always difficult to prove. In practice, I'd always suggest taking the scattergun approach, serve on every notice that's known. The next one is break options. So if there's a break clause in the lease, if it's a tenant break clause and the tenant follows the conditions in the clause, so they serve the notice, they comply with everything else, the lease will terminate on the break date. Nothing more is needed. It's a different situation if it is a landlord break right. If the landlord follows the conditions in the break clause, it will only determine the contractual term. And that means that a landlord needs to serve a Section 25 notice as well to bring the statutory tenancy to an end. So the upshot is the landlord can't subvert 54 Act protection by including a break option. The next one is mortgagees in possession. So this occurs when landlords stop paying their mortgage or they default. In those circumstances, lenders will repossess or they'll appoint a receiver to deal with the property. Where that repossession has happened or a receiver has been appointed who is in receipt of rent and profits, Section 67 of the Act steps in, and that basically says all notices are then to be served on the lender and not the landlord. So there is, in fact, no need to serve on a landlord in those circumstances. Typically, where repossession happens or when a receiver has been appointed, a tenant is notified by the receiver or by the mortgagee, the lender, and from that point onwards, provided when it comes to the receiver, you know that they're in receipt of rents and profits, because they will usually demand it from the tenant, or say that all rents and profits should now be directed to them, you can proceed on the basis of Section 67. The next issue, which always throws out problems in every walk of life in property law, is the registration gap. So take the situation where the landlord sells. So they assign their reversionary interest in the premises, but they're not yet registered at the land registry. They hold equitable title. The buyer holds equitable title. The seller remains the legal title holder. In that circumstance, who serves what? Well, notices have to be served on the competent landlord and by the competent landlord, and that's defined within the Act, albeit it doesn't make it very clear. In Pearson and Alio, Lord Justice Norse held that the competent landlord for the purposes of the Act is the legal owner. So whilst in the registration gap, it is the seller who is the entity on whom the section 26 and 27 notices must be served, and the entity who has to serve the section 25 notices. Conversely, looking at a situation where the tenant has assigned, assigned their lease to someone else, not yet registered at the land registry. Unfortunately, there is no clear answer to this. Tenant is not defined within the Act. Reynolds and Clark, which is the practitioner's guide on renewals under the 54 Act, says that the tenant is presumably the person in whom the tenancy is vested. Now, I'm not convinced that answers the question. Legal title to the tenancy will only vest upon registration. So whilst in the registration gap, the assignee will hold equitable title, the assignor will hold legal title. It is likely that it will follow the case law on break notices. So in Sackville UK Property Select and Robertson Taylor, Mr. Justice Fancourt held that an equitable assignee, so the buyer, one who is yet to acquire legal title by registration, cannot serve a break notice. So in that situation, you would have the seller, who is the legal title holder, giving notices under the 54 Act. Now, obviously, that can throw out no end of issues. Typically, in exchange of contracts, in the contracts, it will provide for a situation where the buyer, notwithstanding having no legal title, can act for all intents and purposes in the name of the seller whilst they're not registered, or until such time as they are registered. The next situation is a predicament whereby you don't know who is occupying the premises, if you're the landlord, or if you're the tenant, who is the competent landlord. So who do you serve notices on? Now, there's a mechanism under the Act, under section 40, where you can serve an information request. The counterparty will have 1 month to reply. If they fail to reply, the sender can ask a court to order compliance or award damages. So it's a statutory breach of duty. In effect, clients are usually loath to go to court to ask for compliance or award damages. Typically, they scattergun and just serve notices on anyone and anything going, because the costs of taking the matter to court may be disproportionate. But the option is there, and I would always recommend serving a section 40 notice. I have seen it go along with the actual statutory notices, the section 25s and section 26, section 27s, just to make sure that when those notices have gone across, they have been served on the correct entity. If the response is no, it's not, then you can serve fresh notices. The last topic I wanted to touch on is subletting. If a tenant has sublet part, they will be in occupation for the purposes of the Act of only part of that premises. So they will only be able to renew or have a right to renew in respect of the part that they're still in occupation of. The landlord can, in those circumstances, force them to take a lease of the whole. But I think for the purposes of, for the tenant's knowledge, they only have the right in respect of the part that they're occupying. Now, an issue has cropped up time and time again where a tenant has sublet the whole. If they've sublet the whole of the premises, then they are no longer in occupation for the purposes of the Act. This has caused particular issues when it's come to Airbnbs and short-term holiday lets. There is a vast body of case law now which provides guidance, still relatively unclear, but from a straightforward perspective, if you have granted some form of underlease, then you are granting exclusive possession to another party and you are no longer in occupation for the purposes of the Act. So it's certainly something to bear in mind. Perfect. That's the end of my part. Jasmine, if you want to move it on to Peter.
Good evening, everyone. I will be speaking this evening about the procedure relating to business lease renewal claims. I have 3 key points or themes to bear in mind at the outset. Next slide, please. The first is that one needs to look in particular when considering procedure at Part 56, specifically Section 1 of Part 56, which comprises a grand total of 3 rules, and of course PD 56. I will be making lots of references in this talk to Practice Direction 56, and I will use the shorthand of PD 56. And I will also use the shorthand for the Landlord and Tenant Act 1954 of the Act or the LTA 54. I've just mentioned Section 1 of Part 56, and that deals with the landlord and tenant claims, and that is defined as including a claim under the 1954 Act. So that's the first point. The second key point or theme is that when looking at the procedure under Part 56, but PD 56 in particular, there is a difference between unopposed and opposed claims, with different requirements applying to each. According to CPR 56.32b and PD 56 3.1, an unopposed claim, unsurprisingly, means a claim for a new tenancy under Section 24 of the LTA 54 in circumstances where the grant of a new tenancy is not opposed. Now, of course, that does not mean that there's no dispute, as the terms of the new tenancy will likely be in dispute in such cases, but that is an unopposed claim. An opposed claim is defined in 56.32c and PD 56 3.1 as either a claim for a new tenancy under Section 24 in circumstances where the grant of a new tenancy is opposed, so on one of the grounds under Section 30, or the claim is for termination of a tenancy by a landlord under Section 29(2). So that's the definition of an opposed claim. The third theme or point to bear in mind at the outset is that PD 56 differentiates between the requirements that apply when the claimant is the landlord and the requirements that apply where the claimant is the tenant. So these 3 themes or points are things to bear in mind when considering what procedure applies when dealing with these sorts of claims. Which court? Both the High Court and the County Court have jurisdiction to deal with matters under the LTA 54. See, in that regard, Section 63(2) of the Act. However, claims under Part 2 of the LTA 54 are generally and should normally be commenced in the County Court. See CPR 56.2. However, they may be commenced in the High Court if the claimant files with the claim form a certificate stating the reasons for bringing the claim in that court verified by a statement of truth, as per CPR 56.223. Rather more restrictively than might be suggested by the actual rules, PD 56 2.2 provides that only exceptional circumstances justify starting a claim in the High Court, and such claims should normally be brought in the County Court. So far as commencing proceedings in the High Court is concerned, PD 56 2.4 and 2.5 provide circumstances which may, in an appropriate case, justify starting a claim in the High Court are if, 1, there are complicated disputes of fact, or 2, there are points of law of general importance. Paragraph 2.5 goes on to provide that the value of the property and the amount of any financial claim may be relevant circumstances, but these factors alone will not normally justify starting the claim in the High Court. These provisions are fairly similar to those in Part 55, which will be familiar to those of you who deal with possession proceedings and are thinking about issuing in the High Court. So it is very rare, in my experience, for Part 2 LTA 54 claims to be issued in the High Court, even where the rent is very high or where there are disputes, heavy disputes of fact, and generally these claims need to be issued in the county court. And in terms of the consequences of starting the claim in the High Court when it shouldn't be, PD 56 2.3 provides if a claimant starts a claim in the High Court and the court decides that it should have been started in the county court, the court will normally either strike out the claim or transfer it to the county court on its own initiative. This is likely to result in delay, and the court will normally disallow the costs of starting the claim in the High Court and of any transfer. So the moral of the story is really do start proceedings in the county court. Finally, in terms of which court, when we're talking about the county court hearing centre, which is the one where the claim is made and issued, will transfer the matter to the hearing centre serving the address if the court of issue isn't the one serving the address in the first place. And in that regard, see CPR 56.21. Which level of judge? As most of these claims, as you hopefully have gleaned, should be in the county courts, it is only the position in the county courts that I will consider. LTA 54 claims are usually dealt with by circuit judges. In this regard, see paragraph 11.1A2 of Practice Direction 2B, which provides the following proceedings, ... will normally be allocated to a district judge. Any claim, ... except ... claims for a new tenancy under section 24 or for the termination of a tenancy under section 29(2) of the LTA 54. So that would suggest very strongly that circuit judge is the way to go. However, pursuant to paragraph 11.1D of Practice Direction 2B, the designated civil judge or supervising judge's nominee can give permission for a district judge to hear such a claim. So you need that permission in order for a district judge to be the appropriate judge. So generally, these sorts of claims will be before a circuit judge, and this is something to bear in mind when sorting out directions for such a claim. Also on this slide, I deal with time limits. This is governed by section 29A and section 29B of the LTA 54. By section 29A, subject to section 29B, the court shall not entertain an application from a landlord or a tenant for a new tenancy, or an application by a landlord to terminate a tenancy if it is made after the end of the statutory period. So this is a limitation period, as it were, for these sorts of claims. The statutory period is defined as a period ending either when the landlord gave a notice under section 25 on the date specified in this notice, or where the tenant made a request for a new tenancy under section 26 immediately before the date specified in this request. Section 29A goes on to provide that where the tenant has made a request for a new tenancy under section 26, the court shall not entertain an application under section 24(1) which is made before the end of the period of 2 months, beginning with the date of the making of the request, unless the application is made after the landlord has given a notice under section 26(6). I made mention there of section 29B, and that provides that the parties can extend the statutory period by agreement, provided this is done before the end or the expiry of the current statutory period. Claim forms. The first question to ask is, does Part 7 or Part 8 apply? Where the claim is unopposed, the proceedings should be started using the Part 8 procedure, as amended by Part 56. See, in this regard, CPR 56.33 and PD 56 2.1. Where the claim is opposed, the proceedings should be started using the Part 7 procedure, as amended by Part 56. See CPR 56.34 and PD 56 2.1a. In all claims, opposed or unopposed, PD 56 3.4 provides that the claim form must contain details of 1, the property to which the claim relates, 2, the particulars of the current tenancy and the date and method of termination and the current rent, 3, every notice or request made or given under sections 25 or 26, and 4, the expiry date of the statutory period under section 29A and or any agreed extended period provided for or agreed under section 29B. Those are the provisions in respect of all claims, but PD 56 goes on to make further specific provision for certain types of claims. So in unopposed / Part 8 claims, the appropriate claim form is Form N208. Where the claimant is the tenant, PD 56 3.5 sets out additional prescribed information which needs to be included in the claim form. And where the claimant is the landlord, PD 56 3.7 sets out what needs to be included. In opposed Part 7 claims, where the claimant is the landlord seeking an order under section 29.2, the claim form must contain the further details listed in PD 56 3.9. I haven't set out what those requirements say, but they are fairly clear from PD 56 itself. In respect of opposed claims, the grounds of opposition must be pleaded in the claim form. In that regard, see the case of Desbroderier and Segalov, which is a pre-CPR case, but still of relevance. And furthermore, the claim form must contain no more than the grounds of opposition which are stated in the Section 25 notice or the counter notice to a Section 26 notice, in which regard see Hutchinson and Lambeth. Before moving on, it's worth mentioning that specific consideration needs to be given to the situation where the landlord seeks to determine a tenancy on some other basis than a statutory ground under section 31 of the LTA 54, i.e. on the basis that the tenant lacks security of tenure under the Act. Such an application is not a termination application under section 29.2 and is therefore not an opposed claim for the purposes of PD 56. Therefore, the landlord could seek a declaration as to security of tenure in Part 8 proceedings ungoverned by Part 56, or alternatively could bring a standard possession claim. And indeed, I have encountered a lot of possession claims that are of that ilk. Multiple claims. In the interests of time, I won't go into this in any detail, but there are references to the relevant provisions on the slides. The provisions there stated provide mechanisms both under the Landlord and Tenant Act 1954 and under PD 56, which enable the precedence of claims to be determined. For example, where the landlord makes an application for termination, but where the tenant has already made a claim for renewal, or where there are multiple applications for renewal from the tenant, from the landlord. Parties. This is something that Ashley has addressed already, but from a procedural perspective, particular mention is worth making in respect of the following, in that PD 56 3.3 provides where a claim for a new tenancy under section 24 is made by a tenant, the person who in relation to the claimant's current tenancy is the landlord, as defined in section 44, must be a defendant. Now, the person or entity who meets that definition can, of course, change during proceedings. And if that does happen, if that person or entity does change during the course of proceedings, that person or entity must be added as a new party. It is insufficient to merely give that party notice, or that entity or person notice, of the proceedings, in which regard see Piper and Muggleton. The court will not have jurisdiction to grant a new tenancy unless all of the proper parties are included. in which regard see Mir and Muskos, which was a case mentioned by Ashley earlier. Service. As we all know, a claim form must be served within 4 months of issue. PD 56 makes specific provision for who should be served with the claim, where the claim is for a new tenancy. Where the claimant is the tenant, pursuant to PD 56 3.6, the claim form must be served on anyone known to the claimant who has an interest in the reversion in the property, whether immediate or in not more than 15 years on the termination of the claimant's current tenancy, and who is likely to be affected by the grant of a new tenancy. Or if the claimant does not know of anyone so specified, anyone who has a freehold interest in the property. So PD 56 3.6 making clear who needs to be served with the claim. Where the claimant is the landlord, pursuant to PD 56 3.8, the claim form must be served on the same people as for the tenant. Acknowledgement of service. In unopposed claims, where the claimant is the tenant, acknowledgement of service must be in form N210 and must include particulars specified in PD 56 3.10. The editorial notes to the White Book helpfully state, none of the sections of Form N210 are particularly appropriate for these particulars, but no doubt inserting them in Section A or on a separate sheet attached to and referred to in the acknowledgement will be considered sufficient. Where the claimant is the landlord, again, the acknowledgement of service must be in Form N210 and include particulars specified in PD 56 3.11. That's the position on unopposed claims. As regards opposed claims, these will be Part 7 proceedings, and therefore the usual provisions apply, i.e. it is not always necessary or appropriate to file and serve an acknowledgement of service. However, PD 56 3.12 provides that where the claimant is the tenant, any acknowledgement of service must be in Form N9, and any defence must include particulars as set out in paragraph 3.12.2. Where the claimant is the landlord, the same as for the claimant tenant applies, i.e. Form 9 for any acknowledgement of service, and specified information must be included in the defence as set out in PD 56 3.13. Evidence. So far as unopposed claims are concerned, as I'm sure you know, the usual rule for Part 8 claims, which of course these are in Rule 8.5, is that, among other things, when the claimant files the claim form, they must also file any written evidence on which they intend to rely, and the claimant must serve their written evidence on the defendant with the claim form. However, that provision is disapplied in unopposed lease renewal claims by CPR 56.33AI. Instead, PD 56 3.14 provides, where the claim is an unopposed claim, no evidence need be filed unless and until the court directs it to be filed. As regards opposed claims, in respect of such claims, PD 56 3.15 provides, where the claim is an opposed claim, evidence, including expert evidence, must be filed by the parties as the court directs, and the landlord shall be required to file his evidence first. It's important not to overlook that last bit. The last bit means what it says, so the landlord's evidence, including expert evidence, must come first, with the tenant responding to it. Preliminary issues. In respect of opposed claims, specific provision is made for preliminary issues in PD 56 3.16, which provides that, unless in the circumstances of the case it is unreasonable to do so, any grounds of opposition shall be tried as a preliminary issue. By way of examples of when it might be unreasonable to do so, this might be the case where a ground of opposition is disrepair, and the tenant is proposing a term of the new lease to address that disrepair. And it also might be the case where points of dispute on the terms of a new lease are very limited or non-existent, such that it would be inefficient and a waste of time and resources to have two separate hearings. Discontinuing proceedings. A tenant can discontinue its own proceedings, opposed or unopposed, as per Part 38. However, the landlord is more limited. In respect of a landlord claimant in unopposed proceedings, the landlord cannot withdraw the proceedings unless the tenant consents, as per section 24(2)(c) of the Act. The landlord may not withdraw an application under subsection 1 above unless the tenant consents to its withdrawal. In respect of a landlord claimant in opposed proceedings, pursuant to section 29(6) of the Act, the landlord may not withdraw an application under subsection 2 above unless the tenant consents to its withdrawal. So the landlord is more limited in discontinuing than a tenant. Interim rent. PD 56 3.17 to 3.19 deals with this. 3.19 provides that where there are no proceedings on foot under the LTA 54, the Part 8 procedure should be used, and that paragraph makes provision for what should be included in the claim form. Where proceedings are on foot, a claim for interim rent under section 24A shall be made in those proceedings, either in the claim form, the acknowledgement of service or defence, or an application on notice under Part 23. Other useful things in Part 56. Tacked on to the end of Part 56 are two potentially useful things. The first are draft directions for an unopposed lease renewal claim, which are worth bearing in mind as a starting point for directions in such cases. And the second is a standard form listing questionnaire for renewal claims. So both useful as a starting point in those sorts of cases. That concludes this very whistle-stop tour of Part 56 and PD 56. Thank you all very much for listening.
Okay, well done, everybody. You're nearly there. You've just got me to listen to now. And my colleagues have done the hard part of dealing with the actual law, and I'm just going to give you some ideas on things that I've thought about over the next 20 minutes or so. So things I'm going to cover, this is sort of a random collection of things that I've picked up over the last few years when doing these kind of commercial, opposed commercial lease renewal cases. I'm aware that some of my instructing solicitors are in fact on this call, and they will I suspect they will know precisely what cases I'm talking about over the course of this session. So you'll see on the slides there's four main things I want to look at. What I've described as wait or ambush, last minute applications. I'm going to then have a think about strikeout and summary judgment. Okay. Wait or ambush, and you'll see that I've put on the slides an excellent picture to cheer you all up of the cover photo for Take That Patience album. In the usual course of things, and we are of course here just talking about opposed lease renewal claims, the techniques and strategies and tactics for unopposed claims are totally different. So we're just focusing on opposed claims for the purposes of my section. Dealing with the kind of usual course of things, right? The standard kind of situation where a landlord served a section 25 notice and then sits back and waits to see whether or not the tenant makes an application for a new tenancy. And normally it's in the landlord's interest to sort of sit around, wait and see, because if the tenant doesn't make the application in time, the tenant loses the right to a new lease. And that's kind of the normal course of things, all right? That's in most of the cases I've worked on, that's what happens. But there might well be scenarios in the odd case where actually a different approach is required. So what if you're acting for a landlord and that landlord needs or wants to move more quickly? In those circumstances, the landlord has the option to get ahead of the curve and apply for a termination order under section 29(4) instead of waiting for the tenant to make their own application. Now, there might be situations, for example, where this is really a good idea. So I had a situation where my client, landlord client, had in fact got to quite a progressed stage in terms of wanting to redevelop premises, had got planning permission, had got all the finance in place, and even was at the point of almost signing construction contracts, but hadn't yet sorted out removing the tenants that were in occupation and was really behind with that side of things. In that case, it was a situation where the only sensible approach was to get ahead of the curve and issue a termination order claim as soon as possible and pretty much straight after they were entitled to do so. So thinking now about timing, this can be done by a landlord after notice has been given. So in these circumstances, we're talking about either a landlord's section 25 notice or a landlord's response to the tenant's section 26 request. If the statutory period has expired, obviously, then you're out of time. So what this gives the landlord essentially a strategic and timely advantage, because a landlord can do so immediately after they've served that section 25 notice. They're in control of knowing that they want to serve a section 25 notice. They're in charge of knowing if, for example, they're proposing to serve a counter notice in response to a section 26 request. They know when they're going to do that. So a landlord that is pushed for time can get its termination order claim lined up already, and then essentially serve the relevant notice and then issue the claim almost straight away thereafter. And in those circumstances, the tenant's not going to be in a position where they can respond quickly enough and get ahead of things and put their application in first. And it may well not be in the tenant's interest to do so anyway, particularly if they want to stay in possession for as long as possible. So this is going to be your odd case, but there are very occasional situations where, in fact, the patience approach that we saw on the last slide is not actually the best one for your client. And it is worth thinking about, do I need to advise my client on applying for a termination order rather than waiting and seeing whether the tenant applies for a new lease or not? Okay, right. The next thing I want to talk about, and I know that this will be familiar to many of you, is last minute applications. Now, I know there's something about 54 Act lease renewals that just attracts last minute practices, okay? I know that most of the time it's because the client is hanging on because they're hoping to potentially settle. I know sometimes the instructions come at the 11th hour. I know sometimes you might be told by a client, here you go, here's the notice I served 6 months ago. And you're in a desperate situation to do things at the last minute. Obviously, before I get into this slide, the best thing to say is please don't leave anything to the last minute. It's terribly stressful for council. So politely, could you just not send us instructions at the 11th hour asking us to draft a claim? That's just a quick one from me. But if you are in a last minute scenario, well, what's the situation? Where do you stand? Any claim for a lease renewal must be made within the prescribed time. What does made actually mean then? Made is one of those situations where everyone thinks they know what it means, and it probably does mean what we all think it means, but nonetheless, there's some risk involved. So actually looking at the case law, it's pretty obvious, isn't it, that if you file an application and that application is issued by the court before the deadline is up, then quite clearly you're in good time. But what about a situation where, well, actually, I've filed my application in time, but the court, as we know it does these days, sits on it for several days, several weeks, perhaps several months, depending on where you are, and it's not issued till some point later. Now, the kind of consensus of the position is that that's okay. It doesn't matter. As long as you have lodged it at the relevant point in time in advance of the deadline, then you're okay. And I've put on the slides a case called Ali and Ali that kind of supports that position. That is also the position, as I'm sure you guys will know, when considering limitation periods under the Limitation Act 1980 And of course, we're dealing with a different statutory regime, but it seemed pretty clear that a similar approach would probably be followed under 54 Act claims. And, you know, the Limitation Act position is that a claim is brought for limitation purposes on the date where the claim form is received at the court office, so not on the date when it is issued. And I think it's reasonably safe to say that that is the same approach. But I flag up here a case called Gravesend County Court ex parte Patchett, and that was an interim rent case, so loosely under the 54 Act. And in that case, the court took a slightly different approach and essentially said that the relevant time was not when the landlord's application was sent into the court in February 1990. Actually, the relevant time for the purposes of when the application was made was a much later date when the court actually bothered to issue it. So the point I make is, fundamentally, I think we can be reasonably confident that it's the date where it is received by the court and not the date upon which it is issued. But generally, can I suggest try and avoid having that argument as best you can and don't leave these to the last minute unless you really have to. If you do end up in a scenario where you are at lastminute.com and you are having to lodge your documents, your claim at the last minute, then make sure you have evidence of when that application was actually received by the court. If possible, I suggest you have someone go and do it in person and get a receipt. If you're dealing with if you're dealing with a court where you can lodge things electronically, of course you can keep the covering email where you did that, but having that evidence is going to be crucial, because if the other side wants to take a point about it, you're going to need to show, well, when was the document, when were the documents, when was a claim actually received by the court, when did you put it in? And you don't want to be in a position where you are awkwardly saying to your client, well, I know a paralegal took it to the court, but I don't know precisely what time or on what day. Make sure you keep very clear records of that. And then on the slightly awkward question of, okay, well, what if the time fixed for making the application, i.e. the deadline, expires on a day where the court office is closed? And the kind of classic scenario is where parties have agreed an extension, but unfortunately they've agreed an extension without actually looking at their calendars. And as it turns out, the date falls on perhaps Good Friday, and the court office is closed. Helpfully, there is some authority on this point, and that is the case of Hodgson and Armstrong. And essentially that case was precisely that scenario where the relevant dates were just over the Easter bank holiday. And the court concluded pretty decisively that the time essentially will be treated as being the next day when the court is open. So you have got a bit of grace essentially if the deadline falls perhaps on Good Friday, that the next day when the court office is open essentially is the time at which you can put in your claim. As I say, please don't put yourself in that position. Can I also suggest that if you are agreeing an extension to the statutory period within which you can make an application, you have a very careful look to see what date that falls on. And if it's the end of March, if it's some point in April, be all the more careful to ensure that it doesn't fall on a bank holiday, so that you don't end up in a dispute about when it was received and whether or not it is deemed to have been lodged on a date that was valid or not. The other thing just to flag up at that point is, and I know Peter's already mentioned this, you can agree an extension to that period, but you need to do so in advance of the deadline and you need to do so in writing. And again, it's hugely important that you have evidence of those two things, because you don't want to end up in a scenario where you're having an argument about whether the court still has jurisdiction to grant a new lease or whether actually the time has expired and perhaps in the case of a tenant, the right to a new lease has in fact been lost. This is an area where unfortunately negligence claims are rife, and because of the strictness of these statutory time limits, you need to be all the more careful. So don't rush and try as best as you can to avoid doing these things at the last minute. The next thing to say on this topic is about settlement. Now, I know, as I've experienced, that opposed lease renewals often settle. All of mine in the last year or so have settled, and that tends to be a bit distracting. I've often found actually that I might be instructed at the last minute either to draft a claim or an application, or indeed to attend, for example, a case management conference. But you can feel from your instructing solicitor that actually the focus is on settlement. The parties are desperate to settle this, or they in fact feel they know that it's going to settle, and that's really where all of the focus has been. But it's really, really important, and I can't emphasize this enough, that you do not allow settlement discussions to derail your application unless an extension has already been agreed. And when I say that, either you've agreed an extension or you've got a final binding agreement for a new lease. Not an agreement that's subject to lease or subject to all sorts of other things. It has to be a final agreement, because this is precisely what happened in the case on the slides, Akins and Solomon. In that case, the tenant had been offered and accepted a new tenancy of business premises that was said to be subject to lease. And because the tenant was reassured and thought, okay, that's fantastic, I'm going to get my new lease now, didn't apply to the court for a new tenancy within the statutory time limit. After that, the landlord subsequently refused to complete the transaction for the new lease. And then when the tenant said, well, hang on, landlord, you must be stopped from denying my entitlement to a new lease, the court disagreed. The court said, well, no, that wasn't a concluded agreement, and granted a possession order. If either party can still withdraw from that agreement, then you're not safe, and you need to make sure you put in a protective application to the court. I know it can feel frustrating. It's additional cost. It's also additional work. But ultimately, if you haven't got a final agreement or you haven't agreed an extension, you need to put in that protective application. That's a real, really important point. And I'm sure many of you that do these cases know that already, but I can't reinforce it enough, because unfortunately, as I say, this sort of territory is one where if you don't quite know what you're doing, the scope to get it wrong and for there to be really serious consequences are quite huge. Okay, so those are my thoughts on timing. And before I'm going to just go back a few slides. Hang on. Sorry, getting ahead of myself. Just before I move on, I just wanted to reinforce that point. Timing is everything in these cases. Insofar as possible, try to avoid last-minute instructions and last-minute applications. Okay, the next thing I want to talk about is strikeout. Now, there are on the slides what I see as being three of kind of the key situations in which a strikeout application might be appropriate. Now, I'm going to talk for a little while now about strikeout and then summary judgment, partly because I think these are tools that those of us that are litigators more generally use in what I describe as normal litigation. The normal run-of-the-mill kind of litigation, we think about strikeout or summary judgment. But I think partly because the 1954 Act has got its own sort of procedure, its own practice direction, and frankly, the people that work in it are kind of used to dealing with these cases and have kind of got a formula for how they deal with them. Strikeout applications and summary judgment applications don't tend to come up as a possibility. I'm very rarely asked, okay, you know, should we be considering strikeout here, or should we think about a summary judgment application? Because there's a process, everybody knows what the process is, and those things don't seem to come into it. But there are some scenarios where, and they're going to be the kind of the odd cases, but there are some scenarios where a strikeout or summary judgment application might be appropriate. So the first situation is an obvious one, and we've kind of touched on it already. If the application has been made out of time. So if, for example, classic scenario, a Section 25 notice has been served, the time for issuing a claim has expired, and the tenant then makes their application thereafter, and there'd been no agreement to extend time. That might be the classic and most easy, straightforward scenario where a landlord could apply to strike out the tenant's claim. They're out of time, the court doesn't have jurisdiction to grant them a new lease now, and ultimately they're at the mercy of the landlord because they've lost their rights. Now, if you're contemplating making that kind of application, you obviously need to be armed with some information. You can't just make the application because you've seen that the notice of issue says it was issued, a month after the deadline. What you're going to need to do, and this feeds into what we were saying earlier about deadlines, is find out when the tenant sent that claim in, when it was received by the court. And that's easy. All you need to do is write to the other side and say, we're a bit concerned that we don't know whether your claim was issued in time. Please provide us with evidence of the time at which it was sent to the court or received by the court. And if you get that evidence through, you can then decide, was it in time or was it not? If you get carried away and make an application without asking that question, I think you're probably at quite significant cost risk. Obviously, if you get sort of a non-response, or the other side are a bit cagey or don't provide you with that evidence, you then need to take a different approach and decide whether to seek out information from the court. Now, we all know these days that unfortunately the courts are stretched, their administration is not fantastic. You might end up spending quite a bit of time on the phone or indeed emailing the court to find out when the claim was received by them. Now, the court should stamp documents on the date they're received, even if they're not issued. So there should be some record somewhere. It's just a case of actually trying to extract that information from the court. And I actually had burned by this kind of experience relatively recently, because I had a situation, it wasn't a 54 Act claim, in fact, it was a forfeiture claim, where the tenant had issued the claim for relief from forfeiture literally the day before the deadline, the 6-month deadline in the county court for relief. And there was a question over, was it in time or was it not? Because it had actually been lodged. The first one that had been lodged was defective in various respects, and then when it had been sent to the court the second time around, it was after the deadline. And the reason I raised this is because my instructing solicitors were incredibly diligent and did contact the court and did ask them for information about when the documents were received, and they received information back from the court, but unfortunately it became clear later down the line that actually the information they'd received was not accurate. So there is an element here of, if you're relying upon information that you've been given by someone on the phone, a distant call centre, you might need to treat it with a pinch of salt. But it might well be that it is worth making the application, particularly if the other side has been refusing to give you the information that you require. And as I say, if it was out of time, it's a pretty black and white point. And if it was out of time, you've got a slam dunk strikeout application. So that is certainly one to consider. The next situation where a strikeout application might be appropriate is where there's been procedural failures or failure to diligently prosecute a claim. Now, obviously, the threshold for a strikeout application needs to be high. It can't just be, well, they were late with one thing. But I have found, particularly in 54 Act lease renewals, and for the reasons I explained earlier, where settlement is the real focus of the parties' kind of concentration, that the court procedure and the directions and the rules kind of get swept away and ignored. In fact, I've had situations where I've been instructed to attend a CCMC where no one served a cost budget, no one's prepared any directions, no one knows whether expert evidence is required. Now, obviously, if both parties are in that situation, a strikeout application it is not going to be a possibility. But if you're in a scenario where the other side are essentially non-compliant and have sort of had a series of non-compliance with the rules and the practice directions, then you should give serious thought to whether you should be applying for strikeout. It might be that actually the first thing you do is apply for an unless order and see what happens. But it can be the case that you find the litigant on the other side just isn't engaging. Often, if the other side are unrepresented, they don't understand the process and are not really engaging with the process, you might find that a strikeout application is in fact appropriate. You might also find a situation where these claims can sometimes drift for quite a long period of time. And if the other side are sort of refusing to prosecute what is their claim, you might find or might consider a strikeout application. The next situation, quite obvious situation, it seems to me, where you might think about strikeouts is if the lease, if subsequent to the claim, the lease is forfeit, the circumstances have arisen that means that the lease has been forfeited. Now, again, you need to think carefully about this, and it's going to be the unusual case where a strikeout application would be appropriate. I'm thinking of a situation where, for example, it's really obvious, perhaps because of the nature of the breach, or because of the way the tenant has behaved, that no relief from forfeiture will be granted. Perhaps, for example, because the tenant hasn't applied for relief within the statutory timeframe provided by the County Courts Act, or where the tenant has outwardly expressed that they have no intention of applying for relief. Now, you might think, well, that seems like an odd scenario. Why would the tenant not seek relief, but nonetheless be engaged in lease renewal claims? It happens. Honestly, it happens. So if you're in that scenario where there is the lease has been forfeited, and the likelihood of the tenant getting relief is really very limited or non-existent, then rather than proceeding to a trial, perhaps many months, perhaps even years down the line, a strikeout application might be a much more proportionate way of getting the claim over and done with much more quickly. Great. The final situation is where, and this is a really good one, and this actually does come up quite a bit. What if the tenancy ceases to be one to which the Act applies? And there's a great case from 1963, I&H Kaplan and Kaplan, where the court made it very clear that the tenancy, throughout the proceedings, throughout lease renewal proceedings, the tenancy must be one to which Part 2 of the Act applies. So the tenant needs to still meet the requirements of the 54 Act to entitle them to security of tenure, to entitle them to a new lease. So the most obvious type of situation is where the tenant ceases to occupy the premises for the purposes of its business, goes out of possession, goes out of occupation, and is no longer occupying for the purposes of their business, such that the appropriate thing for the landlord to do in that scenario is to apply for strikeout of the claim. The tenant's not in occupation, they can't possibly be entitled to a new lease in circumstances where they no longer meet the requirements. And that seems to be the sort of the most clear and obvious way to get a claim struck out. Now, obviously, again, it's going to be the unusual case where a landlord has got sufficient evidence that the tenant is not in occupation for the purposes of their business. You need to be pretty clear and pretty certain about that before making one of these applications. If you just think that they might not be in occupation, then you're going to need to do a bit more digging. You don't want to find that actually the tenant just puts in a witness statement a few days later saying, oh, well, actually, you know, we've gone out of occupation for a few weeks while we carry out redecoration works. You know, then your strikeout application will be dead in the water. But there are situations where this happens, and I've got a case at the moment where something like this has happened. So do think about that. If something has changed, and sometimes these cases can go on for a really long period of time. If something has changed and actually the tenant no longer meets the requirements of the Act, strikeout is a quick way to try and get it resolved. Okay. Next thing to think about is summary judgment. As I said, it is going to be the most unusual types of cases, but they do crop up, and it is something to give some thought to. So just a quick reminder, I know you guys probably remember this, but just a quick reminder, summary judgment test. Either the claimant has no realistic prospects of succeeding on the claim or issue, or the defendant has no realistic prospects of successfully defending the claim or issue, and there is no compelling reason why the case or issue should be disposed of at trial. Simple, simple. So what's the kind of case where summary judgment might be appropriate? Think of a scenario where a landlord might be able to apply where the tenancy is opposed on fault-based grounds. So we're thinking here about breaches of the lease, significant breaches of the lease, perhaps significant and persistent non-payment of rent, for example. Now, obviously, those things are often fact-based. If, however, the facts relied upon are not disputed, so take a situation where the tenant accepts they are in significant rent arrears, or it's indisputable that they're in significant rent arrears, then it might be appropriate to think about summary judgment. Similarly, if you're in a situation where the breaches of the tenant's lease are so serious, but also are admitted, then summary judgment might be appropriate. Now, it's only going to be a case where there's sort of overwhelming evidence, or evidence that is not really disputed or can't realistically be disputed by the tenant. Rent arrears is perhaps the best example. You've got a scenario where the tenant has got 2-3 years worth of rent arrears, on the brink of insolvency, and the prospects of them paying off those arrears and then showing that they're going to be able to pay the rent going forward by trial are non-existent. That might be the type of case where going to trial is not worth it. It's just not worth it. And actually, the appropriate approach is to say, no, let's go for summary judgment. We just need to deal with what the arrears are and make it very clear to the court that there's no realistic prospect of the tenant succeeding in the claim. Now, point to flag here, of course, when you're dealing with fault-based grounds, so persistent non-payment of rent or other breaches of the tenancy, then the court still has a discretion about whether to grant a new lease or not. So when making a summary judgment application, you still need to deal with that aspect of it. And that's going to really feed into the question of, are these things so serious but also indisputable that no court is realistically going to grant a new lease at some point down the line at trial? Okay, so we are talking about one of those cases where it's pretty clear, pretty slam dunk. But summary judgment could save you months, like I say, years of time, rather than having to go to a contested trial. The second kind of scenario to think about is where you're opposing, and again, I'm sort of thinking of this from a landlord perspective. If you're a landlord and you're thinking and you're opposing the grant of a new lease on grounds F or G. Now, just as a reminder, I'm sure most of you on here know, ground F is what is informally known as the redevelopment ground. And the crucial thing there is where the landlord needs to show its intention. And then ground G is kind of, again, loosely referred to as the owner occupation ground, where the landlord needs to show that it intends to go into occupation for the purposes of business carried on by him or as his residence. Now, these cases, I'm sure you know, it's all about the landlord's intention, whether the landlord can establish the requisite intention, but also show that they're likely to bring that intention actually actually cause it to happen. All right. So in these cases, it's incumbent upon the landlord to put their best foot forward. The landlord gives disclosure. It's the landlord that provides the evidence. And realistically, the tenant often can only put them to proof. They can challenge them on what they say, but the evidence and the ability to prove that ground is in the landlord's hands. So that also means in a really strong case where the landlord has got overwhelming evidence, the landlord might find that actually there's no realistic prospect of the tenant resisting their grounds, because they can show so overwhelmingly that they're going to meet ground F or meet the conditions of ground G. Okay, now it's going to be a strong case. It's going to be a situation like the one I described earlier, where the landlord has got planning permission. They have already got finance in place. They've already on the brink of signing construction contracts, where their evidence is so strong, no one can really argue that ground F won't be made out. Okay, and in that scenario, it seems to me that it's a really sensible way of trying to get this resolved much more quickly. It might save the landlord months, years, and a significant amount of costs, because it's within the landlord's gift at a very early stage to prove the elements of their grounds of opposition. And the test to be applied, as I've set out on the slide, is whether the tenant has a reasonable prospect of resisting the grounds of opposition at trial. Now, if in reality you've got such a comprehensive case as a landlord, then what's going to change between now and the trial? Unless the tenant can point to, well, the situation might change because if you've already got planning permission and perhaps the time for appealing that planning permission has already expired, it's difficult to see how the tenant is going to mount a successful defence to a summary judgment application. So clearly one to think about. Then the next scenario I just want to talk about, and I'm conscious of time, is well, okay, let's turn that around. Could the tenant use summary judgment as a tactic to accelerate the date by which the landlord has to establish the appropriate intention? And I'm sad to say that, unfortunately, that clever idea can't succeed. And this is what happened in the Summerfield Stores case that I've referred to on the slide. In that case, the tenant tried to basically get ahead of the game and made a summary judgment application early on in the hope of saying, well, look, landlord can't prove their requisite intention as at today's hearing. Crucially, in that case, however, the High Court said, well, it's not a question of whether they can prove the intention today. The question is whether or not they are likely to have the requisite intention as at the date of trial. So unfortunately, bringing forward a summary judgment application by a tenant to kind of say, haha, landlord, you've not even applied for planning permission yet, you can't prove ground F. Unfortunately, that's not going to work. And I think the reality is summary judgment applications, certainly in ground F and ground G type situations, are something that's probably only going to be capable of being used by landlords, and it's very, very unlikely that a tenant's going to be able to successfully deploy one of those in a summary judgment application. Excellent. Right. So that brings me to oh, hang on, let's go back. That brings me to the end of my session, and I have run over by a few minutes. I just wanted to recap, though. The things that I want you to take away from my talk are that these cases require, sometimes in the odd case, require a bit of thinking about, well, what do I do in ordinary cases? Is it one of those odd situations where a summary judgment application might actually save my client lots of time and lots of money? Okay, fantastic. Let's move on to, in the last few minutes, addressing some of these questions. I'm hoping that my co-presenters have spent some time just having a little look at some of the questions and might have some answers. Ashley, I'm going to jump to you and see, is there any questions that you've looked at and you think, yes, I could absolutely answer that?
Well, I think, if I'm entirely honest, I think most of the questions are directed at me, but I'll try my best to answer them really quickly.
Lucky you, lucky you.
The first one is a situation where the contractual expiry date of the lease is, say, 31st of December. The landlord has served a Section 25 notice with a termination date of the 15th of January. The question is, can a tenant serve a Section 27 notice to expire on the contractual expiry date, i.e. the 31st of December, and leave on the earlier date, not the later date? Yes, they can. That's exactly what happened in Longacre Securities and Electroacoustic Industries, a case from 1990. You've got to tread carefully with that case because it has technically been overruled, but not on this point. Reynolds and Clark says that basically it is the correct approach. The next question was, what happens if a Section 26 notice is served with less than 6 months before the end of the contractual term? Does the commencement date need to be moved, and does the term simply continue? So yes, the term will just simply continue under Section 24 until it's brought to an end in accordance with the Act. The tenant has to give at least 6 months notice if it intends to renew, so under Section 26. If the expiry date of that notice period is beyond the contractual expiry date, then so be it. So in the example, 1st of January contractual expiry date, the tenant serves a notice on the 1st of December. The earliest the notice period can expire is the 1st of June, by my calculations. I hope that's right. The tenancy will continue up to that point under Section 24. I clearly wasn't very clear about break notices, so I'm terribly sorry. The point I wanted to make was, if the tenant wants to exercise its break right, then fine. All it needs to do is comply with the conditions in the clause, serve the notice, pay anything that it needs to pay. Why? Because the Act protects them. If the landlord wants to exercise a break right that's in the lease, the 54 Act says no. The tenant has security of tenure, it's got the protection of the Act. So, Mr. Landlord, you need to terminate in accordance with the Act. You must serve a break notice and a Section 25 notice. Now, that Section 25 notice has to comply with the usual rules, has to be friendly, has to be friendly or hostile. If you don't want to renew the lease, then unfortunately, you've got to make out a ground of opposition. Somebody asked, should the landlord serve a notice to quit when serving a friendly Section 25 notice? So notices to quit are only really relevant to periodic tenancies. With a periodic tenancy, the landlord will need to terminate the contractual tenancy and the protected statutory tenancy. So they have to serve a notice to quit plus a Section 25 notice. And then the final situation was where the lease has expired. The parties were considering renewal, but the tenants changed their mind. The landlord has served a letter on the tenant now saying that the tenant is occupying under a tenancy at will. Does the tenant have to give a statutory notice, or can it terminate in accordance with the terms of the tenancy at will? Now, it's slightly complicated. It sounds like the tenant is still in occupation. So unless they've given a Section 27 notice, the tenancy will be continuing under the 54 Act. The landlord can't just say it isn't, and now you occupy under a tenancy at will. You'd say in the question that the lease has expired. So the tenant has to give 3 months notice to serve Section 27 notice. But it sounds like it's in your client's interest to be able to leave on a week's notice. So I question whether it would be possible to serve a week's notice under the tenancy at will. And then if the landlord all of a sudden takes issue, reneges on its position and says, no, you can't do that, the 54 Act tenancy is continuing, I wonder if you've got some sort of argument that there's been an implied surrender, or that the landlord is stopped from challenging it. So I think that's interesting dilemma, would probably need further thought. Co-presenters, do dive in if you think I've got
no, I agree with that. I think it just depends, right? Is it actually a tenancy at will, or is it still a protected tenancy? If it's still a protected tenancy, then you need to give proper notice. But if it actually is a tenancy at will for some reason, either because it wasn't a 54 Act lease previously, and actually it was a contracted out lease that has now ended, it may well now be a tenancy at will. In which case a tenancy at will is terminable on at will. So you could just do it and just say, I'm going, thank you. So yeah, it just depends on the status of the actual tenancy. I agree with you entirely, Ashley. And you might be able to say, oh, well, yeah, the landlord is stopped if afterwards the landlord wanted to say, well, actually you needed to give more notice. Yeah, interesting. Right, I'm just going to answer a really easy question, which was about the slides and notes and presentations. Yes, they will be sent through to you. There was, I think, a question that I was looking at about the wrong court fee. Now, when I was looking at this the other day, I think there is a case that essentially says lack of paying the correct court fee doesn't mean that the claim hasn't been received in time. So I can't remember the case off the top of my head, but if you do a bit of Googling, you might be able to find it. But essentially the lack of paying the wrong court fee or not paying the fee doesn't mean that the claim hasn't been filed or issued in time, or more importantly, hasn't been made in time. Okay. And then Peter, because you've got off so lightly, I'm going to ask you a question. Is the CLCC pilot scheme for referral of claims to the first tier tribunal still operational?
So that's something that is still at the end of PD 56. There is a note on that pilot scheme, and it seems, so far as I'm aware, that has ceased as of around January this year. I think owing to jurisdictional concerns about the FTT being able to deal with claims like this. The FTT, of course, being a creature of statute, as it likes to tell us from time to time. Yeah, so that has gone. So we're stuck with the county courts and their joys. The only thing I would add to that is that there is, of course, PACT, professional arbitration on court terms, which is something that is obviously not the FTT or that pilot scheme, but is another way of dealing with these sorts of cases, and can be cheaper and easier. And it's something that parties in cases I've been involved with have done.
Brilliant. Well, excellent. I think that's probably all we've got time for this evening. But before we go, I do want to thank you all, those of you that have managed to stay till the very end. Thank you so much for being here. You will get the slides later on, and do keep an eye on our marketing, because the next nuts and bolts session will be coming up in November. There'll be another collection of barristers, property specialists dealing with another topic for another webinar at that time. So thanks again, and have a lovely evening.